Hello bar takers, it's Lisa Duncanson, your bar exam guru. Today is Sunday, just 2 days before the California bar exam in July. So I just wanted to create this video today so that I could give you some final tips. Hoping everyone does well, and I want to give you a little boost of confidence. So most examinees today are feeling stressed because it's a very stressful undertaking, and most examinees feel like they have not studied enough and they need another month or another 2 weeks or even just another couple of days. But you don't have that, and that's how everyone feels. And it doesn't really matter what you've done up until now. I mean, of course it does, but you can still pull things together in the days ahead. You have Sunday today. It's late morning, and you have this evening, and you have tomorrow. And so let's get into it. Oh, by the way, please subscribe and like the video. I would really appreciate that. I want to do more of these, and if I know that this is useful to students, then I will do a lot more. So one of the things that you want to do, of course, you're supposed to memorize, but you don't want to be memorizing paragraph-long outlines. In other words, paragraph-long definitions in these longer outlines. You need to have something more concise. There's lots of resources. We have one. I'm not going to be able to ship anything to you at this point, but hopefully you have put together a list of issues or rule statements or flashcards, something that you can go to that doesn't require you to look at 150-page outlines per topic, because that's not realistic right now. So that's one thing. The other thing that you want to do is review essays, but I don't want you to review them as though it's a test. I want you to expose yourself to as many essays as you possibly can. And our students who took the cram package got about 40 essays. Our students who take our full course get nearly 200 essays. You have resources for these essays. You can get a lot of them for free. I wouldn't worry about any of the released essays on the California Bar website right now, because they're not likely to repeat those anytime soon. It's more important to see the ones that have dropped off, or even just reviewing essays that are from your course. So those are likely to be model answers, not the released answers. I have a license to publish the released answers, and I believe I'm the only one who does. But you can access them, and you just can't publish them. So you can access them, and if anyone has trouble finding them, just reach out to me. You can call us at 213-529-0990, and I can send you to some sources that are available online. So when you're going through an essay, right now, you should not be punitive and trying to test yourself. You're going to be tested plenty on Tuesday. So right now you want to read through an essay, read the fact pattern, spend 5 or 6 or maybe 7 minutes on it, and think about what the issues might be. You can even jot them down on the fact pattern, but I would not be doing an outline. In fact, if your bar person or course tells you that you should spend 15 to 20 minutes outlining, that is crazy. You have an hour, and you need to use as much of that hour to provide an answer. Most of these answers that the bar embrace are very long. You don't have to compete with that length, but you do have to provide a lot of content in a short amount of time. So if you can get writing within 6, 7, 8 minutes, that's ideal. 10 minutes is okay, but anything more than that is too long. So when you review essays, read the fact pattern. You don't even have to commit to what the issues are. Read the answers and study them carefully, and look for what both answers had in common. Anything that you thought of that's not in the released answers, you need to get rid of that. Anything that you missed, or honestly, oh, I wouldn't have seen this, don't be upset about it. Tell yourself, look, I saw it now, and make sure you know why it's there. And if that might just be reading the answer and their analysis clears it up for you, and sometimes it might mean that you need to spend a few minutes on a substantive outline, and that's fine. But this is your personal gold mine. Whenever you're going over essay answers, especially the ones that are released from the California bar examiners, you are seeing what they embrace. You are seeing what they think is a taking by force such that it's a robbery. You are seeing what they think is a place where you should talk about a transmutation. Even though there wasn't a transmutation, you have to come up with these things sometimes. Often actually, and that's why it's so critical to see the released answers, because model answers would not bring up a transmutation when there isn't one. But you want to look at these essays because you want to be able to give the bar exam graders a breadth of knowledge, not just that you know the ballpark issues, but you know the issues that could come up in tandem. So for example, defamation was tested fairly recently. But when it's tested, they always want you to address intentional infliction of emotional distress. And a lot of people just plain don't know that. Of course, there's usually an issue with vicarious liability. Specifically, it's usually respondent superior. And while most people know that, it's easy to miss it. So respondent superior, you get points for that by setting it up right away. Before you get into your defamation call, you would want to address intentional infliction of emotional distress. It won't be provided to you as something that's supported by the facts. But here's the thing, if you have an attorney, when you're an attorney and you have a client come into the office and they say, I've been defamed, because everyone kind of knows what that is. And you say, okay, what happened? And they tell you. And then you say, well, you ask questions like, have you lost sleep? Are you getting counseling? Do you feel you need counseling? Has this affected your marriage? Has this affected your place of employment? And so what is intentional infliction of emotional distress? It requires that there be extreme and outrageous conduct. A defamatory statement could be extreme and outrageous. And so you won't go through the full definition of IIED on a defamation exam unless they ask you to, but you will bring it up and say, here the plaintiff may also recover, in addition to the defamation argument that follows, for intentional infliction of emotional distress by showing that the statement made, and you can even say the statement there if you want to, was extreme and outrageous and could possibly have caused them damages. And that's it. So what you do is you're just grabbing points with the grader. And plus you're providing something, as long as you're using headings for these things, don't be afraid, be bold. This is your opportunity to really pass this thing and win. If you're meek and you're afraid to write on something, that's not good. You need to just go for it. Even if you don't think it's right, you can always unwind it and say, however, a better argument would be. They want to see what your thinking is, what your analysis is. They want to see if you can actually identify the issues. Because when you're a lawyer, you're not going to write a brief or a motion in an hour. They know that. But they want to see if you even have the ability to see the issues. So your rule statements don't have to be perfect. I'm not saying strive for mediocrity, but I'm saying let it go. At some point, you can only memorize so much, but if you really understand how the issues come up in the essays, then you're golden. I just know this to be true. I know it to be a fact, and this is one of the ways I have my students approach the exam. So don't be punitive at this stage of time when you are so close to the bar exam. You're still learning. You should still be learning by reviewing past essays, whatever the source, preferably past released essays, because you see the released answers and you truly see what the bar examiners embrace. But you can get a lot out of some of the national courses essays as well. They just aren't typically California specific. And often they aren't even written by someone who took the California bar, which is okay. It's probably somebody who's really brilliant. But it's super important that you get exposure to as many essays as you can at this point. And the memorization will be so much easier when you see, oh, that's how this comes up. Oh, that's how they test negligence. I know you think, oh, negligence is duty, breach, causation, and damages. But in our classes, I go over a lot of things that you may not know are going to be tested should you have negligence. And negligence is a possibility for this July 2021 bar round. So when you're addressing negligence, of course, duty, breach, causation, and damages, you're going to know those elements to the day you die. But duty breaks out into many things most of the time. The first thing, of course, is you address the standard of care, which is usually the reasonable standard of care under same or similar circumstances. That's what this general standard of care is. However, they like to make it different and have you address a special duty of care. And there are lots of special duties, but the most common special duties are between an employer and employee, so that's respondent superior, or even more popular is a parent and child. So when you have a parent and child on the exam, there's going to be that exception, because the general rule for vicarious liability for parents to be responsible for torts of their children is that there isn't a duty, unless, and this is how they will test it if they test it, the parent knows of some susceptibility or that they're supposed to be on medication for schizophrenia or some other problem. They like to have fires and they've been written up for doing that. Maybe they went to juvenile hall for it. Whatever you have in front of you, that will take you out of just the general standard of care, and you'll have a special standard of care. Other places are bus driver falls asleep at the wheel because he took medication and caused an accident and plaintiffs are injured. So in that situation, the standard of care also includes not just the reasonable duty of care under same or similar circumstances, but a higher standard of care because they're a common carrier. And those are the 2 or 3 kind of ways that this comes up. So you really have to know that, and rather than having to memorize every single type of vicarious liability for negligence, you can really focus on just those, and just know that, you know, should you get something else for the very first time they've ever done something else, that you'll figure it out. But that's what they tend to do. And then after that, you have to address whom the duty is owed to. And that requires a discussion of Paul's graph, the 2 tests, which is Cardozo, majority view. You have to state that. You have to analyze the 2 components of the majority rule, Cardozo, which is the plaintiff must be a foreseeable plaintiff in the zone of danger. And it may be the same facts that establish both of those parts of the test, but you must do both. So if the plaintiff is foreseeable because they were riding on the bus when the bus crashed, they're also within the zone of danger because they were on the bus when it crashed. And so you need to seal up both of those. Then you go to Andrews next, which is the minority view, and it states that a duty is owed to all. Because of your discussion above, certainly a duty would be owed to all. Causation is fairly simple, but I just want to go over it really quickly. There's actual cause, or what you could say is direct cause, and that's always going to be but for. Least substantial, and Summers v. Tice and stuff like that for the MBEs only. You're not going to see that on an essay. So it's but for the defendant falling asleep on the bus, Pat would not have been injured when he crashed the bus. And so that's actual or direct cause. Then you go on to proximate cause. They have never tested intervening causes on an essay. Why? Because the negligence essays and every essay on the California bar exam is a standardized test. Now you may think it's not, but it is. They repeat these over and over and over. If you were to look at 10 negligence past exams from the 80s into the 2000s, you would see they're all pretty much the same. Different names, different facts, but they go through the same pattern. So they like to test special duty. They certainly like to test that on the MBEs, but I'm talking about the written portion today. So with causation, actual cause is easy. Proximate cause is not so easy if you decide to make it an issue. But there's not going to be an intervening cause. So you will simply say here, there does not appear to be an intervening cause between defendant's negligence and plaintiff's injuries, because there won't be one. It's not like the law school exams where you have somebody's hit by a car, they're put in an ambulance, and the ambulance driver and helper did not secure the doors, so they fall out on a gurney on the high hill in San Francisco, get hit again, then they get to the hospital. You know what I'm talking about. You're not going to see that, because the problem with testing intervening or proximate cause is that there's a gradient. You could cut off liability here, you cut it off over here, you cut it off over here. That's an issue for the jury. Don't say it's an issue for a jury. Just wrap it up by saying, here there does not appear to be any intervening acts between the defendant's negligence and the plaintiff's injuries or plaintiff injuries. So then you go on to damages, and I want to tell you one thing about damages that people mess up all the time. I don't know if this is your direction from law school or the bar review courses that are out there, but it's wrong, wrong, wrong. Damages for negligence is not remedies. It's not, you don't want to bring up compensatory, punitive. You don't do any of that until you actually have a remedies part of the question, which you might get. But the requirement of damages for negligence is actual injury or actual property injury. So actual injury, either injury to the person or property loss. And you have to know that, because you may get an essay this round in negligence or whenever. And if you get one that has 3 plaintiffs, I guarantee you that one is only seeking economic damages, and it'll be the third call. And everyone looking at us going, oh my gosh, I have to write 3 separate whole negligence exams. It's crazy. No, you're going to do the first one and you're going to address everything fully. Then the second call, you're going to super back for the rules and even some of the analysis, because the same tortfeasor injured that person, but perhaps in a different way. And then the third call is going to be someone asking for economic recovery because the building had to close down where she worked. So there was property damage for the owner of the store. We're just making up a fact pattern right now. And there was injury to a person because hot scalding water burst out from the wall. So there was some plumbing issue. So that person, the second plaintiff, has physical injury. So those are 2 recoverable things under negligence. But recovering for economic loss only is not available under negligence. And the moment you get to the third call, and you should just know this when you're reading the exam, go, oh, I know what to do with the third call because I watched Lisa's video. Or maybe you stumbled on some essays that actually handle it that way. No recovery, no actual injury. Say that. No actual injury, no recovery. Make that your heading for call number 3. And then what if you don't have time? You've at least said that. Here, the plaintiff is asking for purely economic damages because she wants to be compensated for lost work. Absent having a physical injury or property damage, she cannot recover for economic damages. So done. You don't do any other discussion. That's it. And what that bold thing is that you have just done is something that will make your exam really so much better and so much more likely to pass or be about passing, because they want to see that you have those insights. So I don't have time in this video to go through all of the different things that are unique about every essay, but you have time to look at a lot of essays, and I would really encourage you to do that. I'm trying to think of anything else that I can pass on to you. You want to memorize short and concise rule statements, not a paragraph for each rule. That's crazy, crazy. I think it's even crazy to even review that ever. But to my students' credit, when they come from a course like that and are unsuccessful, because they're so deeply steeped in it, I'm able to get them to pare it down, and they do quite well. But I'm urging you to get out of those thick outlines. If you think, well, I've already memorized it, that's okay. But make sure you know what the basics are of hearsay, because hearsay absolutely could come up on this exam. Anything that was tested last time can be tested again. And if you don't believe me, just look at the history of the bar exam. In October 2020, We had contract remedies essay. It was in the common law context. And then in February 2021, the bar examiners tested contracts remedies in the UCC context. Could they test contracts again? Sure. Do I think it's as likely? No. But remedies is. Remedies. It's somewhere on every bar round, even if all it is equitable lien and constructive trust. And that can show up in community property. It can show up in lots of subjects. So always be on the lookout for remedies. So in addition to remedies, while you may not have a full remedies essay, you could if you saw torts. And tort remedies, we've seen a lot of testing, even with con law, with injunctions and TROs and all of that stuff. So I'm not sure that that would be the direction that they would go in, but they certainly could. And anything is fair game. And so here's my advice to you. If there is a topic that you are terrified of, look at it, review it, get it under your belt, because you can be sure that subject is going to be on the bar. That's just how it works. So regardless of what everyone's predicting, you need to have an even keel with your understanding of all topics. And you're probably like, well, gee, thanks, Lisa. You're telling me this on Sunday before the bar exam. But it can even take like 15 minutes of just reviewing some things that, like, I really never understood dependent relative revocation. So let me go back over that. Let me find an essay in my materials for that and do it. That could take you 20, 30 minutes. Instead of just spending all day long memorizing outlines and definitions, I would encourage you to look over the things that you truly are uncertain about. And that would be a better use of your time, because when all is said and done, so many of the released answers do not have perfect definitions, but they have really perfect or near perfect issue spotting. And you won't be able to spot the issues if you haven't seen some essays. It's just impossible. There needs to be a bridge created between the substantive knowledge that you have in your head to what shows up in the essay answers. That's super important. I cannot emphasize that enough. And you still have time. I wouldn't create a video today about, you need to do 200 MBEs. If you haven't done enough MBEs, then you're done. That's not the case. You're where you are right now, and be positive and know that this is possible. Everyone's scared right now. So try to be not scared. Just say, you know what? My life will not end if I fail. You might think it is, but being a 2-time cancer survivor, I know, and having taken 2 separate bar exams and passed both, one where I was overly prepared and one where I wasn't prepared at all, it's so doable. And you might think, well, that's what she says. She's been doing this for 24 years. Yeah, I have. But I know that what I'm telling you and asking you to look into today and even tomorrow is worth your time. I would not lead anybody astray. I am very passionate about helping students, whether they're mine and enrolled in a course or people that are following my blog. I feel like it's a necessary thing to do, and that it's a good thing to do, and it's just what I want. I want to help as many people as I possibly can. So with all of that said, I'm going to close this video. Wait, one more thing. Okay, I did mention that your exam should have headings. Okay, so the heading should reflect the issues. So if you have negligence, you need to have a heading for duty. You need to have a heading for standard of care, for Paul's graph, because that's when you're getting into to whom the duty is owed. You need to have a heading for causation, actual and proximate. You want a very short discussion of proximate cause. And immediately when they see that, and then you get to damages, and immediately when they see that format, and really clearly on your exam, it's going to look like it's passing. And hopefully it is. But you want to create the benefit of the doubt in your favor. And this is true on the performance test. And I've had a lot of people reach out to me about that. I will try to do another video on the performance test, but I want to keep these videos short because I don't want to take up much of your time. But whatever you do on the performance test, find some type of organizing principles, and that's going to come from two places. The first place is from the senior partner memo. They'll say, draft a memorandum, here's our guy, this is our gal who we're representing, and these have been the problems. They'll give you some little basis to go on. And then they'll say, please draft a memo that addresses 1, 2, maybe 3 things. And then you go to the case file. When you go to the case file, okay, yeah, I am going to address a performance test today. When you go to the case file, don't spend all day on it. It's not something that if you even had the physical copy that you could highlight, I wouldn't bother with that. Just think of it as your fact pattern. The only thing that you might need to cite to would be excerpts of depositions or transcripts of depositions or something in court. But I don't think that you're going to get that. So once you get through the case file, then go to the library. And I really think you should go in the order of it, but make your way through it quickly as possible. And the first thing you should have done when you see the senior partner memo is to write on your I know you have a split screen, so write down the 2 or 3 things they asked you to do and anything else that you think is important, and leave it. And then when you get through the cases, whether it's 1 case that's 9 pages or 4 cases that's 9 pages, they're all about the same length. So don't think, oh, I had 4 cases. The ones I practiced only had 1. It's the same amount of material. They're really careful about that. It is truly a standardized exam, and it is fair, especially now that they've changed the cut score. I'm so glad that they did that. It was necessary. So you're going to find rules that are either factors, 6 factors, 12 factors, or a 3 or 4 prong test. That is your organizing principle. Use that, put it wherever you think it fits, under number 1 or number 2. If you're wrong, who cares at this point? The PT is form over substance. It was form over substance back when it was the 3-hour PT, 2 of them, right? It's a huge part of your grade for the written score, so you need to make it look good and write the best you can, but just don't stop writing. When you're writing an essay, don't stop writing. When I took the bar in 2008, after already passing California, I sat, my computer went down. And the reason I was taking a bar exam again was because I wanted to see what it was like to take it with the laptop. And I signed up 1 year, 1 round, and I chickened out, didn't take it, because I knew my colleagues at the school that I graduated from and taught at would see that I had failed if I failed. And I thought, this is ridiculous. I need to do this for knowing what to tell my students and how the experience is. My computer dies in the middle of about 20 minutes into my PT. And so I shut it down and wait, have my hand in the air, waiting for someone to send me a blue book, but they send me little pieces of paper like this. I'll leave that alone. And what I noticed that was shocking, I looked around the room and everybody was like this, looking up. Like, how do you have time to be looking up in the air when you're writing an exam? If you're doing that, that's a huge mistake. Now, I know why they're looking up, because you can't look to the left, you can't look to the right. This is when exams were in person, right? So now you have to be very careful because they're watching you. But the point of my story is write, 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 write. If you write something that you're not happy with, don't take the time to delete it, just unwind it. Because the more material you have, the more it looks like passing. And they want to see your thought process. That they do. They want to see your thought process. If you leave something off, they don't know if you left it off because you chose to not address it, because you knew it was a failing argument. And I don't want you to go into this on this hand, on the other hand, on this hand, on the other. That's law school. And that's not a good style of writing. So get past that and take a position. Even if you have an objective memorandum, objective means you're telling them the truth. This is how it's going to go. It's not, on the other hand, it could be, goes this way. No, objective memorandums maybe you should think about them as persuasive memorandums, because I've had so many students over the years, both in law school and the legal writing courses I taught, and in criminal procedure and professional responsibility that I taught, who would submit answers that give a whole other side. And there is no other side, okay? It's not appropriate to create an argument that doesn't exist just so you can say, on the other hand. Don't do it. Okay, that is truly it for this video. I may do another one tomorrow, but I'm not going to promise that. I wish you all the very best of luck on the July 2021 bar exam. Should you have some crazy question and you really need to get it answered, you can give us a call at 213-529-0990. Understand, I may not be able to get to you. We may not be able to get to you because we do have a lot of students and we need to put them first. But I wish everyone who's taking the bar exam the best of luck. And please like and subscribe to this video channel. I really would appreciate it. Thank you so much.